The title of today's Brandon's blog is Ontario Family Law. Detailed Ontario Court of Appeal decision allows wife's claim over husband's creditor. What happens when a property is jointly owned between two people and one of them has creditor claims against them and the other person does not? That is the entire question that was resolved by a recent Court of Appeal for Ontario decision in a family law case. My name is Ira Smith, president of Ira Smith Trustee and Receiver Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch until the end of this video because I know you will find it informative. The case described below is all about a husband and wife who were separated but not yet divorced, and they owned the matrimonial home as joint tenants. The husband had a judgment against him, and his creditor, who held the judgment, moved to file a writ of seizure and sale against the property. At the same time, the wife went to family court to have the joint tenancy turned into tenants in common and to have it declared that the husband's creditor who wished to file the writ could only claim against the husband's half interest, not the wife's. And the Supreme Court of Ontario granted that order. So the judgment creditor appealed to the Court of Appeal for Ontario. Down in the blog below, Brandon explains the reasoning of the Court of Appeal, where they determined that the lower court motion judge was correct and that the husband's creditor could only register against the husband's interest in the matrimonial home. Now, the Court of Appeal for Ontario went on further, and the result of their decision is that even if you do not have the situation where there's family law proceedings going on, a judgment creditor or Canada Revenue Agency can only register against the debtor's interest and not the other person or persons who also hold title to the property. The Court of Appeal for Ontario also went on to say that didn't stop or limit a judgment creditor from going after any other property of the debtor they had the judgment against, where the debtor owned the property just by themselves. But as far as joint property, you could only register against the interest of the debtor against whom the creditor had the claim against. And because it's applicable both inside family law proceedings and outside family law proceedings, it is also important in the insolvency world, where you have one debtor who is insolvent and the other person who is a joint owner of property is not insolvent. That joint owner's portion will not be at risk when the creditors of the insolvent debtor come after that person. So I hope you can read the entire Brandon's blog below, because I know you will get value from it. Again, both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you.